in terms of selling a property, I was sent this question a week or two back in terms of tenants' rights when selling, and an agent coming in, and how we market a property is we take photos and we do video, and we obviously have a mandate from the seller to sell the property. So there were two questions in there. One was the tenant was very unhappy to have all of her personal belongings and her furniture in the photos. So how do you then market a property when you can't take photos and you're only taking photos of the outside of the building? And secondly, she said that her lease was only up at the end of February. So why is the seller putting the house on the market now, and why does she have to allow people access now? So
I would always try and revert back to the lease agreement, you know. So, and lease agreements, again, it's something that I've been dealing with more and more, lease disputes, rental disputes. But always try, and I've seen lease agreements that are half a page long, and I've got commercial lease agreements that are 70 pages long. So they come in all shapes and sizes. And you try and always revert back to the lease agreement. So you would try and work that in the beginning into your lease agreement to say, and normally there's provision for access by the landlord to the property with enough warning or notice. They can come and see the property or show somebody the property.
Because I know when we do photos, we can also say to our photographer sometimes just block out the photos if there's any personal photos in the home and like that type of thing. So we do that
I mean,
generally.
Do you, as a tenant, want to move all your stuff into the garden so that they can take pictures? But then also, on the other hand, a landlord would ideally have pictures of the open space before the tenant comes in. So there's got to be a give and take and a bit of common sense there that should prevail. But ideally, work it into the lease agreement so people from the beginning, you know exactly where you stand with all those issues.
And then in terms of selling and allowing access to people, because I know normally in most lease agreements it says in the last 2 months the landlord can market the property for lease or for sale, whichever they prefer. But in this instance, it's obviously 4 months before the end of the lease. Again, is it just sort of the tenant and the landlord deciding?
Come together, and common sense must prevail. But like I say, you can always work. It doesn't. I mean, each lease agreement is different. It could say in the last 2 months, last 6 months, last year. It could be any time. With good notice. But and obviously with the tenant might not be happy with someone selling the property with their tenant. And you've got
because they want to stay on and renew the lease.
Stay on, and of course then that's when one of the rare occasions when you can pull out some of the Roman Dutch law that you studied at varsity, where you got for quip, which means that if you're a tenant in my property and I sell the property, I sell it with the lease agreement in place. So the purchaser will buy it with the tenant in